Hello everybody, my name is Reinhard Bütikofer. I'm a member of the European Parliament, and we are assembling here today in the European Parliament with guests from the United States, Jennifer Hillman, Robert Stumberg, to talk about TTIP. TTIP is the catchphrase today in Brussels. This week is TTIP week, this month is TTIP month. TTIP is the Transatlantic Trade and Investment Partnership that President Obama and the leaders of the European Union agreed to negotiate from July on, probably. And of course, there are many issues connecting the American side and the European side. And as a Green Group in the European Parliament, we have invited experts from Washington to join our discussions and to enlighten us. And here, Jennifer Hillman to my left is a former trade negotiator herself under the Clinton administration, and she's now working with a well-known American think tank, the German Marshall Fund of the US in Washington, which is a very active transatlantic think tank. And to my right, Robert Stumberg, law professor at Georgetown. He does also consultancy with public interest groups like public health or environmental groups or on trade issues. So two real experts. And first of all, let me start by raising one issue that we have been at odds with in the discussions in the European Parliament with other groups also regarding the transparency of these negotiations. Everybody is saying this is negotiations of a completely new dimension. It would be an agreement that we haven't seen before, so it would be easy to say let's create new standards with regard to transparency also. You have experience with negotiations and with practically dealing with the problems of transparency. Jennifer, what would you advise with regard to the necessary transparency for the upcoming TTIP negotiations, please?
Well, again, in the United States, the issue of transparency had always revolved around the process by which the United States Trade Representative, who was doing the negotiations, consulted with the Congress, as well as a wide variety of stakeholders. And in the U.S., it, in the past, got put into a bit of a formal process in terms of what we called fast track for the negotiations with the Congress, and then the negotiations with stakeholders, or the discussions with stakeholders, were largely done through advisory committees. My sense is that on the U.S. side, both of those mechanisms are very rusty, if not even non-existent, given that fast track, that legal authority has expired. And my understanding on the European side is we're in a little bit of uncharted water. I mean, this would be a first very big agreement in which the Lisbon Treaty provisions that give Parliament a very different role than it had played heretofore, a real chance to rethink this. And my sense is there's been a lot of learning on the U.S. side, at least, that it is very important if people are going to understand and have sufficient sort of buy-in and interest in a negotiation to make sure that everybody is included in a very transparent way. Understanding that you have to, at some point, figure out a narrower group to consult with. You cannot obviously conduct a negotiation in front of, if you will, the public. Live on television, you couldn't conduct an entirety of a negotiation. So some parts of it are going to have to be done in a negotiating room, but that doesn't mean that they can't be done in a way that provides a good amount of transparency to the stakeholder community and to the parliaments that are going to ultimately have to approve these agreements. So a lot of room for improvement over where we were in the past.
So when you describe the congressional experience as having gotten rusty, what specific standards would you want to see implemented?
Well, again, in the past, the process was very much one where cleared advisors on specific congressional committees were the ones that saw, for example, negotiating text. And it's, again, not clear whether things like that need to be somewhat broadened out. This is an agreement that is likely to touch well beyond the traditional tariff issues. The traditional tariff issues, at least on the U.S. side, typically went through the Senate Finance Committee and the House Ways and Means Committee.
Yeah.
And there wasn't a sense that you had to broaden it out. But if this negotiation is going to cover, as people suggest, a whole variety of regulatory barriers, issues in agriculture, issues in services, issues in government procurement, issues in a lot of areas, it's not clear that you don't need to significantly broaden out, even within the Congress, who you're including in these discussions and these consultations. I mean, the notion is that the USTR needs to consult on a regular basis with those in the Congress that are engaged in the notion of a TTIP.
Well, not being a member of the European Parliament's Trade Committee, I have no access to the documents so far. And I've been told by staffers from the Ways and Means Committee and Senate Finance Committee that that would be better in the United States. But maybe the standards that we've seen in the States is not enough, and particularly from the point of view of societal stakeholders. So what would be your advice, Robert?
Well, let me begin by explaining the status quo. Is there consultation with advisory committees? Yes. But in our advisory committee system in the United States, there are about 600 participants who have access to the text of negotiating documents. Out of that 600, about 550 represent industrial sectors. Manufacturers have a committee, the chemical industry has a subcommittee, the tobacco industry even has a committee. So you have hundreds of industry representatives with access to text, and literally a handful of public interest participants. And then, of course, maybe or maybe not the congressional committees, but not all members of Congress can get to see the text. They call that transparency, but the public obviously has no access and the press has no access. And people depend on an imperfect tradition of leaking documents to have any public debate whatsoever about these texts. So point one is, I don't think that's good enough. After all, they're not negotiating tariffs. They're not negotiating the regulation of trade at the border per se. In the TTIP negotiation, the main proposals are to begin discussing how to harmonize regulations of products, how to expand into important services, including public services, and whether or not to give foreign investors a special set of rights and a forum for their own disputes. So now you're moving into the realm of domestic courts, the constitutional authority of legislatures, and the most important cutting-edge issues in a global economy with respect to standard setting. And the transparency that's being proposed is secret briefings and consultations that are limited to just a few hundred people, most of whom are in the industry. So what does transparency look like in the view of the folks I work with, the public interest community? It means treating this as what it should be, a major piece of legislation. So in your parliament, if a major piece of legislation is on the table, it's physically there and you can share copies, right?
Yeah.
You can go online and download a copy from a library in any part of the union. So that's what we think of as transparency, where public laws get discussed, circulated, and the text is open for a discussion.
Well, I tend to believe that this is not only about involvement of legislators or specific interest groups or stakeholders. This is also about the general public. I mean, everybody says this is an agreement as none before, and the general public has to understand how much is at stake and how much would be negotiated. So there's also an educational dimension with regard to our voters to understand what the alternatives are that are on the table, and some of them could have a major impact on them. So I think that maybe we can combine also the issue of transparency with highlighting some of the contentious issues that are on the table. Like one that I have bumped into is investor-state dispute resolution mechanisms, where major corporate organizations are using such tools to sue sovereign states over legislation because they feel that their profits are being reduced. I understand there we have a lot of commonality in the discussion from civil society in the US and in Europe, Robert.
Civil society groups have common positions. They're vastly apart from the position of most multinational companies, who are the ones who very much want this alternative system for dispute resolution. We have a lot of history in terms of giving foreign investors greater rights than they would enjoy in the courts of a particular country. In fact, it was Germany which invented the concept of an investment treaty back in about 1953.
Sorry for that.
And it was,
I was born that year.
well, popular ideas are copied quickly, and so the other European nations followed suit very quickly. There are now almost 3,000 of these treaties littering the legal landscape. European Union nations have about 1,200 of them, but almost all of those are between a European highly developed economy and a developing country. The same is true about almost all of the United States investment agreements. So there's a relationship there really which sort of replaced colonialism, in which the dominant multinational companies wanted an agreement to say, if we have a grievance with the government, we don't have to use your courts. Now think about that in the US-EU context.
But this is now the US and the EU, exactly, and both sides have well-established legal institutions. So
and property rights.
Why do we have to deal with that at all? Why can't we take it off the table?
It's again, it's not clear to me. I mean, the other complicating factor in these negotiations will be whether or not the EU is trying in any way to change its current approach to investment. As you obviously know, in the Lisbon Treaty, things were changed because now, in theory, investment law and investment policy comes solely under the competence of the Commission, notwithstanding the fact that right now the United States has bilateral investment agreements with a significant number, a very significant number of the European Union member states, which have been heretofore simply grandfathered. Whatever you had in place just stays in place. And so the question is whether this is a moment or not for the European Union to rethink, I mean, whether or not this sort of crazy quilt, but on the other hand, starting from the German model, approach to investment and investment disputes is one where you want to stay, or whether because it is the US and the EU that are highly developed, with highly developed legal systems, with strong traditions of rule of law, whether this is a good agreement in which to, whether this is the right forum in which to think again about the approach to investment.
Well, why would we dish out privileges to corporations just to satisfy the bureaucratic logic of who is responsible? I mean, we have agreements, investment agreements with, as you say, with many of the major members of the European Union. I don't see an immediate need to change that and to use that as a particular sort of present to the corporate world. Would in your opinion, as a former negotiator, would there be a tough pressure from the U.S. to include investor state?
Again, it's going to depend. My own sense is there's not a lot of dissatisfaction with the status quo. I'm not hearing a lot of dissatisfaction in Europe that we've got to hurry up and change our investment regime, nor am I hearing lots of dissatisfaction on the U.S. side with the status quo. So it's not entirely clear to me. Again, I think everyone will say things about investment, but it's not clear to me whether there is any burning pressure to change where we are
Sounds
right now.
Interesting. I mean, this is what I hear about a couple of topics on the table. If you ask who put them there, who is insisting on having them there, you don't really, in all cases, find an author or someone who says, yes, I'm responsible for putting it there.
I think a lot of it also depends on whether people see this agreement as having implications for other countries or other agreements outside of the United States and the EU, and whether it would somehow send a signal that people think is not a good signal or is a good signal, whether something is or isn't in this agreement. And investment may fall into that category where the concern is, what does it say about other agreements?
Well, look, this sounds curious to me, I must say, because just to subdue the public interest in the US and in the EU to special interest from corporations for the purpose of making sure that what Robert called the neo-colonial instruments will stay in place with regard to the developing world, that's not a worthy cause from my point of view.
Well, I agree with you, but let me summarize the three theories for why this is happening at all. So first of all, as Jennifer suggested, this would be the first opportunity for the European Commission to step up and be the negotiator. And within the EU, that's a big deal. It used to be the province of the member nations of the EU, not the Commission itself. So this would be the first big negotiation on investment in the Commission's home turf. A second argument is, again, what Jennifer said. Many companies view this as a template which can be used to harmonize the thousands of agreements and perhaps eventually to supplant them, to replace them, so that there's a global multilateral investment agreement, a way of cleaning up, if you will, and coming up with a more rational system instead of the chaos that exists now. And a third reason is that over the past 15 years, we've had some modest success in the United States from the public interest perspective of persuading the United States government to be a little bit more defensive. In other words, to clarify the investor rights so they're not broad and vague in their legal terms. And a lot of companies are not happy with those modest reforms. They look at the older European treaties and say, well, we'd rather go back to that version. And so when the countries commit to harmonize upward to provide the strongest investor protections that either party has, the U.S. businesses see that as an opportunity to go back to the European standard, which from my point of view would be to wash away the last 15 years of progress.
If that be the case, I would say this is exactly the kind of conversation we should have, a transatlantic conversation, yes, to inform each other where the stakes are and where the chances and the opportunities and the risks are. I'm sure this will be a very contentious issue in the European context. It will loom large in the European election, probably. I think this is going to make it more difficult to win public support for the transatlantic deal, to be viewed as a tool for promoting particular corporate interests, where there might be more support for the political project of sort of giving a new spark to the transatlantic marriage, but not necessarily getting GMO or investor state served in the process. One thing I've been missing in the discussion, and not from you, that's why I'm asking you, is talking about what this negotiation could be used for with regard to promoting positive goals, like reducing CO2-heavy fossil subsidies. The G20 agreed to that years ago. Nothing much has been moving forward. Could we use TTIP as a tool to promote such a process, maybe?
My own sense is absolutely yes, and I think this is one of the reasons why TTIP has been viewed by more favorably, or at least as the opportunity to do better things than an awful lot of the other agreements, at least that the United States has negotiated. I mean, this is the first really serious negotiation, if you will, among equals, among the two largest trading countries in the world, and among countries that already have high standards in a lot of areas. And so the question is whether it can be used as an opportunity to even further kind of raise standards. And one of the key ones that I think there's a real opportunity for is in the environmental area. Arguably, both countries care about the protection of the environment. They have approached it in different ways. I mean, many in the U.S. would argue that the Europeans' system is better and has done more, and therefore, if the United States were to take on board some of the things that Europe has done, it would be better. And it is a way in which you could, for example, agree to phase out all subsidies that would support CO2 production. It is a way in which you might figure out a way to address the issue of whether or not you can take into account the process by which a product was made. I mean, like something that the U.S. and the EU could do. You could, in a lot of areas, reach agreements where both sides would agree, we don't want to trade in products that are the subject of child labor. We don't want to trade in products that were made in the dirtiest, least environmentally friendly technology. It may be that as between the U.S. and the EU, you could work out these kind of things that would push for a higher standard in terms of environment, in terms of labor, than you might see in again, in a multilateral agreement, which could be a very positive outcome to come out of TTIP. If this could end up being a way to leverage up standards as between the two, but again, it's going to require figuring out, all right, who has the better standard right now, and can you figure out a way to move up to better standards more generally? If so, I think then there's a lot of positives that can come out of TTIP.
Two questions to you, Robert, in the same context. Do you share the optimism, or maybe second question, to what percentage do you think TTIP will be an opportunity to really promote such issues?
Well, I think much of the talk about harmonizing regulatory standards upward is happy talk. When the governments involved have committed themselves to harmonizing upward for purposes of controlling, reducing costs, or promoting investor rights, that's not an invitation to harmonize upward environmentally. If anything, it'll be pressure in the opposite direction. The only area where I might be optimistic is with respect to subsidies for fossil fuels. Now, in that context, the question should be, why hasn't it happened already? After all, the G20 has supported it, APEC has supported it. In fact, 134 countries in one forum or another have indicated that they too want to see these subsidies reduced. It still hasn't happened. So what the TTIP could add would be a trade compliance mechanism, specifically a clear definition of how to classify these subsidies, which ones are truly distorting and impeding the growth of renewable industries. Number two, a clear process for disclosing what those subsidies are. Number three, an international institution to manage the disclosure process and to keep countries honest. And importantly, number four, a deadline and some form of trade sanctions to enforce those commitments in the long run. Now that would be very politically controversial, but as we've seen in the area of agriculture, the TTIP countries could adopt a peace clause to allow for a reasonable period of time, whether it's 5 years or a decade, after which, though, they could bring trade complaints against each other to enforce their mutual commitment to get rid of these subsidies. To the extent that some of those subsidies are there to protect lower income people, well, you could imagine, just as you have in agriculture, a series of red light and yellow light and green light subsidies, which are treated differently in order to respect those differences between subsidies. So there are systems in place already in trade law to allow for this kind of evolutionary progress over 5 to 10 years, and the TTIP affords us an opportunity to follow that example.
Well, I take from both of your statements that there could be possibly a very useful contribution, but of course it depends, as always, on political will. Our time is up, but I want to end by saying political will, as Al Gore famously said, is a renewable resource. So maybe we can come up with enough political will to put some of these ideas into the negotiation. Thank you for joining us.
Thank you.
Thank you for having us.